So, you have your first patent granted. What's next? Hello and welcome back to Invent Anything. This is John Cronin. In this episode, we're taking you from getting your first patent to actually turning it into a real business value, covering strategies, decisions, trade-offs, separate passive IP from other assets that you can add to this, and how to build, protect, and monetize and scale around this first patent. So from mindset to execution to future, this is a roadmap that you could use to take your patent from just sitting on the shelf or being on the wall to make it work for you.
Inventions keep the world spinning. From fire and the wheel to today's high tech, inventions power change. Turn your inventions into reality. Learn how to get your ideas to market. This is Invent Anything with John Cronin.
Today we're going to cover two parts. In the first part, we have 6 different topics, and in the second part, we have 4 topics. So in part 1, we're going to cover basically a congratulations and some things to think about, because as a first-time inventor, that's a great achievement. Then in topic number 2, we want to talk about ways that you can create value. And I'll talk about pros and cons of each one quickly, and maybe you can identify which one or 2 or 3 are for you. And then I'll start going through some of those ways of providing value. Topic number 3, for instance, talks about litigation and something you should know about called evidence of use. Topic number 4 talks about licensing or sale considerations, and here we'll talk about some of the tricks of the trade. And topic number 5, we'll talk about setting up an M&A, merger and acquisition. This is something that independent inventors and people with their first patent do quite a bit if their patent is covering a business that they're also in. And in topic number 6, we'll talk about setting up for copycats. Inevitably, your patent will be looked at by lots of different entities, maybe competitors, and they're going to try to copy or invent around you. And you need to know that now and get ready for it, if that's of interest to you. Then we'll jump into part 2. In part number 2, we'll have 4 different topics. Topic number 7 of the 10 would be to set up to do deals with customers, vendors, and leveraging your brand, where topic number 8 is to set up your patent and maybe a potential business to raise money. I've even helped inventors that just have a patent to raise money to continue the process of getting more patents or building prototypes. And then we'll talk about how to use these different ways of raising value, a hybridization, if you will, of using 2 or 3 or 4 to mix and match these. And then if you hang in there with me, I'm going to talk about the future, where your patent becomes actually an agentic AI. As a matter of fact, your patent may, even with 6 months or a year from now, become a sentient being. I know that sounds weird, but we can jump into that and talk about it. And then we'll wrap up. Now, I definitely think that the audience here is first time I got my patent. But if you're watching this podcast, it maybe you think you know about patents, but maybe you want to sort of think more about many different sophisticated ways to use the patent you might know of. You may be a founder or a leader of a small team, and this patent is something that you think about creating value, but you want to avoid mistakes. And maybe you want to turn the IP into a revenue generation mechanism here. Maybe you're an operator in some sort of growing or larger company, and this is your first patent. And here you might want to do things like level up your patent in the background for litigation or licensing or an M&A, or even some competitive positioning. You could be an executive and looking to make decisions now that your company has this patent or you have this patent for the first time. What are the practical things that you could do to tie it directly to deals or valuation or risk mitigation? There are those people that want to try to connect the dots. They're doing other things in their business, and the patent is yet another thing. And they would like to figure out a way to connect those dots as to now what does the patent do to my business, to my market, to my product, to my technology, to sales. And then finally, having this patent allows you to sort of be a person that maybe you want to think towards the future. You know, what's the next step? What should you cover off from the patent? Should you have another one? Should you define trade secrets? What should be your tactics? There's a lot of different reasons that you can think about how to move forward here. So this is John Cronin, Invent Anything. And coming up in the first two topics, we're going to talk about congratulations, you're in the 0.1% club. And what means to you is that you can call yourself an inventor. And we can start thinking about all those things about how you can create more leverage. And then we'll talk about value. And we'll break down the perceived versus real value in a patent and talk about litigation and licensing and M&A and copycats at a high level before we delve into the specifics. So hang on. Okay, let's get into it. Topic number one, congratulations is in order. Um, and some things to think about. And I really meant that. I did a little search to figure out how many people actually get a patent issued in the United States and how many people there are in the United States. And you're basically 0.1% or less of people that achieve this as a goal. That's incredible. Congratulations. I remember when I had my first patent back in 1983 or 84, and I was really proud of it to the point that I thought that I could become an inventor. See, my background, which you can sort of get online and take a quick look at, is I was a top inventor at IBM when I was there because I got my first patent and I believed I could keep doing it. Um, and then I went from IBM to start my firm, IP Capital. And over the years, I've had the opportunity of working with 2,000 companies, 15% of Fortune 500. And I am an inventor at work. I have 2,500 patents. Not a lot of people around that can say that. The reason why I put this podcast together is I recognize a lot of people that are coming to us these days to help them raise value are really first-time inventors, first-time patent holders. So I really do mean it. Congratulations, and you should really sit back and have a cup of coffee or a glass of wine or whatever, and just think about what you just did. You have something that you can legacy-wise tell your children about, tell your grandchildren about. You are an inventor. Another part of the congratulations really is to sort of think about, did you or did someone else actually spend this money to get this patent? Reason why I bring that up is if you actually paid for your first patent and you got it issued, that's a very strong reflection of your belief in your idea. However, if someone else did pay for the patent, um, you're smart because you got your idea leveraged through somebody else's capital. So either way, I think there's two different points of view. But the congratulations to the both of you if you have an investor. Also, another part of congratulations is you survived the scrutiny of the patent office. That's no small feat. I mean, about 50%, 55% of the people that get into the patent office, get it through that very difficult time. And basically, prior art is being used to stop you from getting your patent. As a matter of fact, getting a patent today is a lot harder than getting a patent 10 years ago or even 5 years ago. It's incredibly hard to get a patent through, say, from 100 years ago. So comparing yourself as an inventor to past inventors, you've actually done something that's really kind of amazing. So what are you going to do for the next time? Are you going to come up with another invention and file patents? But you should sort of congratulate yourself on this point as well. I would also say that you should congratulate yourself because I'm certain that you got this patent for a specific reason, right? Maybe this is something that you did to improve your business, or maybe in the world that you're living in, you think this patent is going to do something for you, like generate revenue or prove to, the business that you are the inventor, use it for brand. So congratulations, whatever that reason is. But this podcast is going to hope expand and give you more advanced basics and even some advanced strategies of what to do with the patent. One of the things about the congratulations is now that you've got the patent, maybe the celebration is over and maybe it was short-lived because now you're at the other side of the patent, which is how do I get the ROI out? Whose responsibility is it? Are you going to sit and wait for somebody to knock on your door to ask to buy your patent or get a royalty for licensing? What about the forward costs? Have you thought about that? You recognize that there's going to be other fees, maintenance fees, 3, 7, 11 years in the US. We have to pay some pretty heavy fees. Also, you might have continuations, and there could be more office actions and more fees. ROI becomes a huge effort to sort of consider. Congratulations, but Now you have to sort of move on, don't you? One of the nice things is um, you're either the patent owner or the non-patent owner. You see, you're always the inventor if this is your first patent, but you may have assigned the rights to the company. At IBM, I didn't own any of these patents because IBM did. My 2,500 patents, all my clients own them. It's a reflection of my business model. So what do you do if you're the patent owner and you're the inventor? You're in a very unique club, but there's more responsibility on you. On the other hand, if you have your first patent and the company is the patent owner, it's a very interesting dynamic to want to see that your patent gets some value for the business. So, congratulations. I don't care whether you're the patent owner or the non-patent owner, but there is that difference. You might not have thought about that. Another thing is, I meet a lot of inventors who tell me that their patent is really the result of years of work or thinking in some area, and they finally got the patent. Boy, that's really kind of cool that you're able to get something issued on something that could be your life's work. That's a big legacy step. On the other hand, you could just be totally on a fishing expedition. You got this first patent and you want to see the value. In either way, whether you're a risk taker or this is your life's work or somewhere in between, I would say congratulations there as well. Another area for congratulations, I think, would be so you're an inventor, right, with this first patent, and you can look back at this achievement, but do you know what? No one could take your name off of this patent. Boy, when I was at IBM, I would get patents on things, and then discussions would come up about, who invented that technology. When you had the patent, it was easy to prove because your name was on it versus he said, she said. One of the patents that I developed very early on got a $500 million licensing award. And the company actually gave some of the inventors, some recognition. There were hundreds of people who worked in the technology, but it was easy to define the inventor. So you have your name on this patent, and no one can take that away. If you're interested in the dark side of this, look at my podcast on the patent as a poison pill. Because if somebody else got the patent and you don't agree with it, or somebody else got the patent in your company, there's a lot of things you might want to find out and worry about. And then I think another congratulations would be in order, even if this is your last patent, now that you know the process, you've done it. You might look forward though and say, that you've done it once, you can do it again. That was my line of thinking. If I could get one patent, I could get two. If I could get two, I could get 10. If I could get 10, I could get 100. And today I have 2,500. Nothing could stop the power of us inventors to keep going forward. And I would challenge you to continue this process now that you've gotten the hard part behind you. Now that you have one, you can have as many as you want. So finally, congratulations. And I hope that you have a continuation open on your patent because that means you can get more patents and basically change claims based upon your invention. And congratulations, and again, and I hope when you get that letter from the companies that say, how would you like to buy a plaque on the wall? I would say go do it. If you don't do it because of the expense, you can still make your own plaque, buy a piece of hardwood, get a 3D printer, make your own plaque, and away you go. So congratulations again. Let's jump into topic number 2, ways to create value. Which ones are for you and some pros and cons? First of all, let's talk about perceived versus real value. I have been famous to say over the years that patents have more of a perceived value than a real value. You see, the real value is if you have to take somebody to court and spend a lot of money, but you win and you get a check and you kick them out of the market, maybe. That's real value. Doesn't happen that much. On the other hand, if you get a check through licensing, that's real value as well. But did you know leveraging a patent for getting a raise in your business from your boss, leveraging a patent for having an M&A happen, leveraging the patent so your customer can see the value and you get the sale. There's all these things about the perceived value. Even walking into a room, sitting across a large company with you as a single person with a patent, have the authority of a large company because you have the government behind you because the government allows this right and then allows you to defend this right. So there's a huge amount of value. Walk into a room where you're the only inventor. The other people don't know how you did it. They look at you to have a higher value. So there's a huge difference between the real value and the perceived value of a patent. So let's just click through some of these ways that you can make money. One is litigation. Down the road, somebody violates your patent. The pros are you can appear as a giant, as I just mentioned, because the government's going to help you, allow you to file a patent suit to stop others from making, using, or selling. But the cons are this costs a lot of time and a lot of money and a lot of aggravation. So I have podcasts that you can look at on litigation to go more deeply into it, but I just want to cover that off. Another way, a little bit less innocuous, is licensing. And this generally is you're getting a check for someone to license your patents for usually royalty rates, anywhere from 0.5% up to 15%. Depends upon where the technology is. Medical devices more 10, 12%. Software more 0.5%, 1%. There's a lot of variation. But also, patent licensing can be on any deal that you can cut. There's no requirement of paying a royalty rate. It's any deal you can cut. $100,000 up front with $100,000 every quarter for them to get a laboratory license to your patent, for instance. Anything you can imagine. So the pros are you generate revenue. The cons are, in order to do any of these things, whether to get a royalty or whether to generate some sort of income from a deal, requires real expertise. So take a look at some of my podcasts on how to sell your patent or license it. Because you'll find out that it takes real expertise. A big part of our client base is to help them get value out. Another one is M&A, merger and acquisition. You might not know this, but if a company is going to buy your company and it looks at its revenues, you could get 2, 3, 4x your book revenue for acquisition value or 10, 15x EBITDA. However, with patents, what we found is you can go 10, 20, 40, 50, even 100x in a multiple over your top line revenue. You see, what happens is large companies that see you have patents want to make sure that another large company doesn't buy you so that the other large company has the patents against them. They don't really care about you as much as a small entity, but they certainly care about their competitors. So pros are this helps make the M&A happen and gives you a large valuation. The cons are, once again, that takes real expertise. Another area for making value out of a patent is to stop copycats. So if you're one of those inventors that's a patent owner but also a business owner, you now can say patent pending. You can label it and put it on your product or your service. And that's going to stop people from copying you. No one's ever going to call up and say, hey, you got a patent and we didn't copy a good job. That ain't going to happen. But you may find that your business is improving in the market because you got that patent filed. It's a huge market leverage. The con is it's hard to tell if people are actually copying you, but if they do, then the next part is how do you get them to stop? And so I did a whole podcast on this copycat that you might want to take a look at. Another thing that most people don't recognize is that the value of patents in customer space, generally you get a 35, 34% higher gross margin on a product if it's patent protected. The pros are that it might help you close a sale with the customer because you could say, don't shop me around, I own the patent. On the other hand, the con would be it's a very sensitive balance to bring up patents with your customer because your customer may think that that's kind of like not allowing them to expand their business. It becomes complex. So it has to be kind of shown as to that you're the patent owner and that helps their business. Again, that takes a little bit of finesse to do that. What if you have a vendor? Almost any company wants to expand by improving their inventions on a value chain. Everybody wants to put more patents in their customer space or the vendor space. So your vendor might want to invent in your space. So if you have a vendor, one of the great things about it is you can control pricing generally. What your vendor might charge you because you own the patent on how to use their product, and you might allow them to take a license from you so that they can sell their product to other competitors of yours. So the pros are it helps you lock up the value chain. The cons are that vendors can get wise to this whole thing, and all of a sudden they're developing their own IP. I can't tell you how many times in my life where I help people get their first patent, where they call back a couple of years ago from then and say, now my customers and my vendors are getting a patent as well. At least you got the early position and you got value out of it. Better you than them, right? And brand is another area that As the innovator, the pros are you get to boast that you did it. You started this market. So the pros are very broad for marketing. The con is, once again, that you as the innovator may start a brand war because innovation may be what the brand becomes about, and competitors are going to innovate as well. One of the things that I found, one of the greatest perceived value in getting a patent is it enhances your valuations for raising money. And so the pros are you can meet an inventor checklist, trigger investment, get a higher valuation. But the cons are, and there's a number of podcasts I have on this, that you need to pick the right investor because every investor doesn't give value to patents. And you can learn from some of these podcasts. It's like a bookcase where some investors think if you spent money on patents, you've wasted your money. Some investors won't do a deal unless you've got a patent or two. So you've got to figure out to raise money to enhance your valuation to find the right investors. I can tell you more and more investors today are actually looking for more patent companies, especially in AI, where if AI is going so fast, by the time you develop an AI piece of software, somebody else can just look at it and use AI to automatically create the new software, making a copy of it. So patents will become one of the only ways to secure value. And then another point is that I've mentioned about 6, 7 areas. And in the podcast, 6 ways to make money, we go in depth on each one of them. But there's a hybrid, and we'll talk about it, where you can do, maybe leveraging with the customer to get higher margins and close more sales, and then use the patent to help raise more money, and then use the patent to do an M&A at the end. So 3 parts of value. So you can do a hybrid of these. So the pros are patents almost always create value if you focus on it. But the cons are, and this is the reason why I started the podcast, as a first patent owner, you might not know any of these things I'm talking about. This this podcast may be something that you play 2, 3, 4, 5 times, take some notes, or get a transcript, and use your AI to put together a plan for you. Cons are most people don't know how to do value creation of patents. But with a little training and experience, you could produce a lot more value than just sitting on the patent. So take a look at my 6 ways of getting value out of patents. And hopefully this podcast here is a one-stop shop for all those other areas that you might want to think about. So coming up, we're going to investigate litigation, plus its sort of other side of the coin, evidence of use, and we'll talk about that. We're going to discuss enforcement, the real cost of it. Do you have a patent that's truly litigation grade? Using continuations, how do you size damages? How do you get ready for that defendant who's going to analyze your IP? And what are some of the critical do's and don'ts before calling your lawyer? I'm not a lawyer. I have lawyers that work with me and for me, and lawyers are my best friends. I've had lawyers as friends and advisors for the last 45 years. So I'm not putting the practice of law down. Basically, the practice of law is the practice of law. The things that I kind of do around the legal profession is I have over 50 services in my company. Things are more inventor-led or business grade and sort of thinking about it. All the services we have, I think 70, 80% of them lawyers don't even do. So I'm talking about the business and invention value of the patent. After we go through litigation, then we'll shift to licensing or sale, and we'll cover how to raise the valuation. A building block is your IP story, and how you tie claims to real use, how you can structure field of use, how you can use licensing as a Trojan horse to drive even bigger outcomes. So stay tuned. So topic number 3, uh, litigation and evidence of use. So there is a podcast on evidence of use you can take a look at, episode number 53 if you want. But evidence of use is basically the idea of having evidence of your claim in a column, if you will, against somebody's product or service that violates it. And you're going claim element by claim element by claim element against your competitive's product. Generally, you need a professional to do this. There's 2 levels to it. You can have companies like mine do the technical part of the evidence of use. If you want to go further than that, you can have a legal read of evidence of use. And that's really important as well. Cost difference is very different for having a technical person do the evidence of use versus a lawyer. A caveat is do not use this phrase evidence of use and do a large language model and expect that the large language model is going to do this for you. That would be disastrous because what happens is if it thinks it knows evidence of use, and you start making decisions on it, that's a terrible error. Um, when we talk about LLMs, and they're all great, they're very useful in any kind of domain. We have hundreds and hundreds of prompts that we use for our different services. We probably have 50 to 70 prompts just on evidence of use because we know the guardrails and the problems. So just that's a caveat. One of the things is the litigation cost, and this is a major sort of blunder. If you decide to litigate against someone, you become the plaintiff, and basically it will take you to get a lawyer anywhere from 50 to a couple hundred grand to put together a case. And then if the defendant decides to fight it, then you're going to go to what's called a Markman hearing. That's a $500,000 on both sides, generally, maybe a little bit less or a little bit more. And then if you go into litigation, it could be millions of dollars. Average litigation, 3, 4, 5 million on each side. And then it's going to take 2 or 3 years, or more. So the litigation costs can be very high. And then most litigations, if you're successful, end up in licensing anyway. But there's lots of papers written on the expenses of litigation. But you should be forewarned. That's a trigger that if you pull it, that's the game of kings as far as I'm concerned. And even with my 2,500 patents and all my experience over 45 years, I absolutely do not recommend litigation. It's absolutely the last thing that you'd ever want to do. It's interesting. Another thing about litigation is take a look at your patent and let's ask the question, is your patent claims litigation grade? You could say, wait, what are you talking about, John? Well, if you go to episode 52, is your patent litigation grade, what you learn at a high level from me is that generally, how many patents are written by literally mapping the product that you're going to sell to the claims that you've written. Generally, they're not. Since about 90% of the patents are written before the product actually goes out, looking at patents claims that overlap specifically your product generally have not been done. And then that means you're abstracting the claim to cover that product specific. So I can't get into the details of this. This is a whole podcast which you can take a look at. But make sure if you ever decide to go into litigation, that your patent's litigation grade. As a matter of fact, if you're thinking of doing litigation, you should spend twice the amount of money with your lawyer to make sure that your patents are litigation grade. Another thing about litigation, vital, is to make sure you have a continuation open. When your patent issued, right before it issued, you get your attorney saying, should we file a continuation on it? If you said no, that's really too bad because a continuation allows you to keep adding more claims from this original spec as the technology or product may shift. So you have a real mark against you if you don't have a continuation. There are some ways to bring a continuation back if you kind of had an error, but generally, don't even really think about litigation unless you have continuations. Sometimes people settle or buy the patent just because there's a continuation in place. Another thing about litigation is you should definitely try to size the damages before you start. It makes no sense to spend $500,000, $1.5 million, and at the end of the day, get 5% royalty rate on a business that has 3 million in market share, which is 150K or something. It makes no sense. So we do IP valuations all the time. You can take a look at our podcast on valuation, but you really should take a look at sort of back of the envelope, what would be the damages. And you can do that before you call your patent attorney. You can just size it up. And that's a very good use for large language models, by the way, figuring out the market size and figuring out if you had 3% of that market, what would it be? Another thing about litigation, which is very important, is before you call your lawyer, there's a lot of do's and don'ts. And this is kind of interesting. You may actually impact your litigation success by when the patent issues. Some inventors, the first thing they do is they get in the office Monday morning and they call up a competitor and say, I got a patent, you better stop doing what you're doing or I'm going to sue you. That's about the stupidest thing that could ever happen if you've done it, because you could get a declaratory judgment where that side says you're disrupting our business and you go to court defending against their DJ before you even get to your claims. you may have done a disservice to your company by firing back and forth emails between you and people in the company saying, we got this patent and company XYZ is basically violating our patents. And then people would argue about it internally with emails. Well, I'm not sure. I don't think so. We better do this. We better. All that stuff is discoverable. All these internal docs and all this stuff about what's going on with your patent. If you ever think of using litigation as a tool, you have to have 100% optics on what you're doing internally. Get that right and then call your lawyer. Don't get that right and then call your lawyer. It's going to cost even more money for your lawyer to help you fix up that. Another thing about litigation is that at the end of the day, it ends up in licensing anyway. So you should take a look at the defendants. Ask yourself, if I sue a company, do they have a lot of money in their treasury? Does the owner live in Beverly Hills? Because they can fight back and they can make you start spending money. If they're litigation prone, even worse. You sue them, they're going to turn around and sue you. Take a look at their patents. Do they have things that counter sue you? I mean, there's a lot to sizing the defendant in terms of litigation. We have a tool created called Sherlock, which basically takes a broad look at a defendant. Another thing about litigation is one of the things you might want to do is perform an inventor round. Again, we have a podcast on that. We have a service on that. We have an 18-point checklist. But if you look at your patent and ask yourself the question, how do I invent around my own patent? You might find that you can get 2, 3, 4 of the patents filed to cover the inventor rounds. Because what do you think the first thing is going to do when someone approaches a potential defendant? The first thing they're going to do is read your patent claims. And the second thing they're going to do is try to figure out if they can invent around you. It makes no sense to try to litigate against somebody if you haven't invented around your own patent. Another thing about litigation is, have you kind of reviewed the kind of things that you might want to do almost as a prep list? Do you have the title? Do you have inventorship right? Have you sized the blowback from the potential defendants? We have a whole list of things that you might want to do to prep the business. Get the business ready because the owners might be in court a lot of their time. That could impact the business. And the last thing is that in litigation, you should really analyze countersuits, looking at what we call freedom to operate, which again is another podcast you can listen to. Do you have freedom to operate against somebody else's patents? The game, many times, is you sue some company, that company goes out and buys a patent to countersue you because you don't have total freedom to operate. So it's another part of the checklist. Okay, topic number 4, licensing or sale consideration. One of the greatest things about licensing is to figure out how big is the market. You might be very surprised that your licensing value is tremendously large because you have a very small coverage of something in a very large market. In some areas where it's heavily tech-driven, like in oil and gas drilling, for instance, even a small invention on a wellhead could be worth hundreds of millions of dollars because of the leverage it has in producing, something that produces wealth. Medical devices, drugs. These are areas that, very large licenses, etc. One of the things, just like I mentioned for litigation grade, is your patent licensing grade. Now, what do we mean by this? Well, sometimes your patents are too specifically worded in the claims, where for licensing, you might want it to have more broad breadth because you want it to overlap variations of your technology. Once again, having your patent written for licensing grade is another matter. You might say to yourself, well, why aren't my patents written for everything? They're just not. They're written for kind of an average use. I mean, there's so many ways to make money through patents that there's no one way to write a patent to cover them all. You'd have to generate 4, 5, 6, 10 patents to do that, I would think, from my experience. Another thing about licensing is the whole thing comes down to expertise. You can jump on podcast 38 and 39, how to sell your patents, and you'll realize there's a whole world there on how to sell or license your patents. For a number of years, I had another company. I was running a company as well as IP Capital called the IP Capital Licensing Company. For 5 or 6 years, with about 10 or 12 licensing executives, all we did was license. We gained a lot of experience in how to tell and to get licensing to happen. Key to licensing is how to develop an IP story. You just can't show up with your patents and say, pay me money. You have to understand their business, their market, their product, their technology, and their use of your invention and convince them. And so it could jump over to episode 24 if you want the IP story. But you really need, if you're going to do licensing, to start developing your story. So get into that and think about that. Develop your story far before you think about licensing. One of the things that's really cool about licensing is that the value goes up if you have a prototype. And in today's market with 3D printers and AI for software, the ability to produce a prototype, the dollars to do that have gone way, way, way down. So generating a prototype really helps. Actually seeing the invention triggers interest. Just having the patent, well, could, but there's more value if you have the prototype. Another thing about licensing is have you sort of tied your patent to the user's use? Meaning, supposing you have an invention that um, would enhance some sort of process of a customer. So supposing you have a new way to income and you have a like a mirror and you figured out a way to um, analyze the reflectivity of the mirror in terms of aberrations. And you've got this kind of new gizmo you just created, which is kind of like a video camera with an algorithm to see how flat the mirror is and how many defects are on the mirror. And you produce that data. And you'd think that this mirror company that's making mirrors will absolutely need this in their process. And you may be right. But it turns out that it would be more valuable to them not only to have your invention, but to have the data that comes out to be something that they can influence going into your tool to modify tool factors or coming out of the tool where they can have certain parameters they can customize as tool factors that drive it to the next process. As an inventor, I do this all the time, but you could take your invention and say, what would the customer have to invent in order for them to use my invention even more? That's tying your invention to the user's use. That will increase the licensing value a lot, showing them that your invention is going to help them. Another thing about licensing is that you might think about not only having your patent, as we mentioned, inventing around it like we did in litigation, but also inventing on top of it towards the user. And then having a set of provisionals, maybe one or two patents and four or five provisionals, because provisionals gives you the ability to talk about it and own it so that they can't take that idea and run with it. Another thing is just like licensing, we talked about evidence of use. Doing evidence of use for licensing, in litigation, we talk about evidence of use. So in licensing, knowing evidence of use is really important. However, I could tell you that if you show up to license, and this was something that we learned over the years in the licensing company that I ran, is if you have evidence of use and you're trying to license it, that's material. You can't sort of talk to somebody about your invention. If you have really good evidence of use and you don't bring that up and then you talk to them about it, you can't kind of contaminate them and make them go into willful. So you should seek a lawyer's counsel here. But if you decide to have evidence of use, you might have a third party do that and blind you from those results and just tell you whether you think the evidence of use is strong or not. But you should probably not get strong evidence of use yourself in doing licensing. Do it at a high level where you assume there's evidence of use, but on the other side, when they ask you, do you have evidence of use, you can honestly say no. Another thing about licensing is there's a lot of business impact to build and then sell something versus licensing. So you have all of the margins when you build and sell. When you license, you're just going to get a very small percentage of royalty on letting somebody else build and sell. So they're going to have costs. And you might do it on total sales or on profit. Most licenses are done on total sales. So you might want to think about whether it's more valuable to build and to sell or to license. Being a first-time patent owner, it's very likely that you were thinking to get the patent of licensing, and that's absolutely great, and you should try to do that. But sometimes you start thinking about licensing. I've seen a lot of companies that go out and try to license, and they recognize, you know what, we should just build and sell this ourselves, and vice versa. Another thing is you could recognize in licensing that you license in field of use. So you can license your invention in a particular field. Let's go back to that mirror thing that I just invented. The licensing field of use could be only for mirrors that have to do with laboratory mirrors. You can have another field of use for mirrors that only have to do with, say, cosmetic mirrors. And so you can draft totally different licenses in different fields of uses to allow you to stop one field but not another. Another thing about licensing is you're licensing more than patents. They'll probably want to know your know-how, your trade secrets, and all that. So you need to get that in order. One of the great things about licensing is that you can use it as a Trojan horse. You literally could show up to license, and as people learn about you, they may want to buy your company or buy your patent. So look at licensing as a Trojan horse. coming up, we'll shift into M&A setup, talk about the hockey stick, give you that story to tell you how real value is obtained in M&A, talk about how to align your patents with the acquirer, how to use citations to pull buyers in, how to align your IP with the buyer's goals, especially globally, how to do trade shows and things like that, and press releases to make your deal visible. And then we'll shift over to copycats, building a strong claim net, using episodes on things like tactics and product watches and things like that, early warnings for DJs, declaratory judgments, and continuations and inventor rounds, and any other kind of countermeasures like FTO to really shut competitors down. So take a listen and come back and we'll talk about the next topic, topic number 5. Okay, jumping back in for topic number 5, setting up for an M&A. I promise you a little story on the hockey stick. If you go to any kind of market space and plot on the y-axis the M&A transaction deal against the x-axis, which was the number of the patents of the acquirer, and you start looking up deals and you kind of find that this company was bought for 6 million and had no patents. The next company was bought for like 12 million and had 2 patents. The next company was bought for 45 million and had 7 patents. And you plot all those dots. What you find is a hockey stick around 7 to 10 patents. Sometimes 10 to 15, 10 to 12 patents in other fields. So basically, let's just say 10 to 12 patents is kind of the average. But there's a hockey stick of value. So you got one patent, but you might consider getting more if you think you're going to have an acquisition. And these are generally patents that are brand new family members as well. So more patents would help and more value. And I think the reason is we work for large companies, 15% of Fortune 500. Well, we've been asked to come in where they want to buy a company, and they ask us for assistance to help invent around the patents. Because if you can invent around it, there's less value. And I think that the thing is, and I can't prove this, but if I try to invent around a patent and land on another one of your patents, it's harder to invent around if you have more patents, right? Because inventing around your own patent, you're going to land on another one. So that's the hockey stick story. So as you sort of think about patents and M&A, think about the hockey stick. Another thing about M&A is that this is where perceived value becomes very real. Remember I talked about this. If you get, instead of 2, 3x revenue, you get 20, 30, 40x revenue just because you have patents, then that's a lot of perceived value. The thing about M&A is you can improve patent filings from the first one that you have, but to create others to connect your patents to the acquirer's use. And the acquirer, if you sort of really study your acquirer, the acquirer could have very different uses for your patents. Your patents may be a Lego block of a larger thing that they're building, and getting your Lego block to overlap the other Lego blocks would be very valuable. One of the things that most people don't realize when they get their first patent is there's citations in the patent, forward and backwards. So the examiner might cite some other patents or other references to show why your patent was different over the prior art. You might decide self-cite patents over some other companies to show, well, you're different than them. Well, let's just say that you want to sell your company to Procter & Gamble. And let's just say that Procter & Gamble's citing your patents a lot. That's pretty cool because it means they have an interest. Or it might mean that the patent examiner thought they should have an interest because you're basically building something that's allowing their patent portfolio to rely on. On the other hand, if you cite Procter & Gamble, you're kind of advertising, your invention relative to Procter & Gamble. Now, Procter & Gamble has competitive analysis teams, and they might find your patent just by that citation. So citations are really important. By the way, the more citations, the better, because there's more value. If you find very important patents in an industry, you'll find out that they're cited hundreds and hundreds of times. At IBM, we had one patent that was cited like 8,000 times. It was cornerstone to semiconductors. Another thing about M&A is you really need to align your patent with the trade secrets in the prior art. I started a company a number of years ago called IP.com, which is a way that you can publish prior art as a defensive publication to essentially help you poison the well around your own inventions. So if someone tries to patent around you or invent around you, they can't because you put prior art in place in order to stop somebody else from getting a patent on improvements. So you can go to the podcast on enabled publication. We'll go to the podcast on trade secrets, because having the know-how and knowing how to protect that is a triple win. You see, there's three legs of the IP stool. One is patents, which we're talking about. A second is trade secrets, which we don't have time to talk about, but it's very valuable. And the third is this enabled prior art. Another thing is, the M&A, the acquirers have a point of view. So their point of view is they're going to try to invent around you. So that's one of the first things you should do if you think that you're going to use your patents as one of the bases for being acquired is to invent around it. Here's a trick for an M&A kind of approach that if you have a patent and products and you think that the company's going to buy you, I have so many times seen that the company's product development gets developed and it moves out of the scope of the patent. So the idea of sitting on your own patent and your product improvements takes a discipline. You may start adding some features that the patent claim doesn't have, and you add a new feature replacing one of the features in your patent claim, and your patent doesn't protect your product. I had one investor say he had a company with 300 patents covering the product. And he paid me to do IP due diligence, which is one of our services, to take a look at the IP of his company if we were going to acquire it. Out of 300 patents that the CEO said protected their product, we couldn't find one patent out of the 300 that basically sat on top of the product. All the patents were done in a totally different direction. The product moved on. So consider that. Another thing about M&A is consider filing in countries that your acquirers have business in. So maybe you file a PCT, Patent Cooperation Treaty, and maybe Procter & Gamble has businesses in South America and in Canada, in the UK, and in Germany. Well, that's the list, right, of your PCT filings. File your patent in other countries based upon the acquirer's business. Don't file it in a country they don't do business in. It won't have any value to them. Another thing about M&A is consider presenting papers at trade shows where at the end of the paper, you basically list your patents. When at IBM at one point with one of the technologies that we had, we basically created a lot of papers in an industry, and competitors thought we were dumb because we were teaching a lot of stuff, but we didn't add the patents to the end of the paper. Later on, there was a lot of copying of the technology. We had purposely not added patents to these group of papers so that others might practice what we were doing, because when they practice it, our patents became more valuable. Evidence abuse became better. Another thing is get really good in an M&A to leverage press releases. You can take that one patent, continuations, knock uses of the patent, prototypes of it, press release each feature. The more noise you make about your patent in the industry, the more that the giant's able to come to you. So consider leveraging patents in an M&A. Now, topic number 6, we talked about copycats, at a high level, but I want to sort of get further into it. What is a copycat? Copycat looks at what you do and basically does what you do. And they try to win because they think they could sell better in the market. Or just recognize you can't have 100% of the market, and by them owning 50, 20, 30% of it, you can all share that piece. The whole definition of the patent system is to promulgate the arts, correct? So if you patent something, that gives you the ability to stop others from making, using, or selling. So let's just say that the market is a box, and inside the box is a circle, which is the space your patent covers. What it basically says to others is, if you want to go in the box, in that circle, you need to pay me a license, or else I could stop you from making, using, and selling. So what happens is it forces them to put a new circle in the same box, the same market, different circle. Copycats don't seem to care. They're just going to copy exactly what's inside your circle. So what you need is making sure you have a very diverse net of claims to make sure that wherever that copycat moves inside that block, you can cover them. Now, we have a whole podcast, episode 27, on how to stop copycats using IP. And a lot of it has to do with things like your website and things like, your description of your technology and products that you're selling. Sometimes you give too much away. But the other part about copycats is that you need to label and mark things so that the copycats knows you have patents. One of the greatest things to do for copycats is to put out a product watch. And this becomes pretty trivial to run this every week if you want, because now you can build a little agent in AI to go out and say, here are my product features or my patent claims. See, are there any companies that have these product features? Even listing the companies that you're worried about. So basically try to match your claims to their website. So build a product watch. Another thing is have an early warning sign. for you to decide if the copycat is copying. What's the trigger for you to do litigation? When do you call them? When do you try to get them aware? Because they may not be aware that they're copying. To use a third party to help make them aware. Have a third party write an article about you have a patent that's covering your product, but there are other companies out there, you're a copycat. And maybe you press release through a third party that the copycat is violating your patent. One of the things that's really great about stopping copycats is having the copycat think that you're stronger than you are. Hire a prestigious law firm, put it on your website, have them do some things for you, but make them think that you have the most prestigious litigation law firm in the world. And so if they decide to go against your patent, they know they're going to go against this prestigious law firm. These are all tricks of the trade of how to stop copycats. Another thing about copycats is it's used for brand selling. That if you do have a copycat, you have to get with your customers and really tune up the volume on the fact that you have patents, that they can't end around you by giving business to a competitor. But generally, a lot of times customers will respect that and buy your product and someone else's because they don't want to get in the middle of a skirmish between you and a competitor. Use of continuations, also very key. You change your patents, getting continuations, getting more claims in the direction of where a competitor may change. The competitor may try to invent around you, but if you have a continuation to file a new claim in that invent around, that would be very useful. Or do an invent around. Another thing about copycats is this invent around system is really highly leveraged because the first thing the copycat will do after they read your claims is to try to invent around you. So take a look at episode 28, how to do that, because it's very important. And then finally, the one thing about copycats is you need to do it free to operate and make sure that the copycat doesn't have patents to assert against you. So in the world of copycats, this is a highly respected use of patents to stop others, but there's a whole world under that to figure out, are they violating it? How to make them know, how to get them to stop, how to improve your position to stop them from copying. So we have our 6 topics here in our first part where I would like to wrap up. So let's go into sort of wrapping up. In topic number 1, we talked about congratulations. We said, you're now at the 0.1% club. You're a true inventor. You get to call yourself an inventor. You've invested a lot of money in this. You passed the patent office scrutiny. You have a great idea that you now believe in, or maybe somebody else believes in it, that they invested in you. You may be feeling other things about this, about the patent. So you may be celebrating it, but now we have to think about ROIs we talked about. Think about all sorts of things like continuations and all sorts of value creation stuff. Is this your life stream or is this, your one-time fishing expedition? We also hit on things like if this is your life's work or just a start either way, that there's a whole bunch of things that you can learn now about leveraging the value here and deciding is this your first patent or your last patent. Either way, we know you get the plaque, you should, but recognize now you got your first patent, as we discussed. There's a whole world out there. You've created a whole business. Take a look at our episode on is a patent a startup? Because you may have just done a startup as well as got your first patent. And topic number 2, we talked about ways to create value. We don't know which one is for you, but we talked about pros and cons. We broke down things like litigation and the cost or licensing, but how it needs expertise. We talked about the 10, 20, 30, 40, 50x valuations of M&As. We talked about copycats, and we talked about things like customer pricing and things like that. Even the hybridization of these different ways to create value. Every path has pros and cons, but the question is, which mix will you choose? And whether you'll actually know how to turn that patent into a real asset, not just a perceived value. Perceived value is really great, though. It will work for you if you let it work for you. In topic number 3, we talked about litigation and evidence of use. We dove into sort of litigation, and the other side of the coin is evidence of use. You should understand whether you have evidence of use before you start enforcing your patents, because there's a real cost, as we mentioned. Is your patent litigation grade? We talked about why you should have continuations, why you should size damages before you start. But we also hit on the real world prep issues, the do's and don'ts, even before you call your lawyer, like things like declaratory judgments and emails and internal documents. We talked about tools like we mentioned our Sherlock tool to help you gauge the total threat of defendants. Talked about running the 18-point checklist and also looking at pressure testing litigation. Can they countersuit? Have you done FTOs, free and operates, against the company you might want to sue before you pull that trigger. In topic number 4, we talked about licensing or sale considerations, and we tried to unpack a lot of differences there. How you start with the valuation. How big is the market? We talked about, is your patent actually written for licensing? The key part. We talked about, is your licensing expertise, strong? Have you done this before? Because you're going to need an IP story. You're going to need some expertise to do that. And we hit some of the podcasts you might want to listen and to bone up on licensing. We also hit on some of the levers, like having a prototype helps, making sure your claims are really tied to their use, your licensee's use, building provisionals and event rounds, looking at evidence of use and trying to structure that, and then trying to bundle know-hows and trade secrets and enable publications, the 3 legs of the stool, to try to put together this sort of licensing and recognizing that you could use it as a Trojan horse to leverage your business. In topic number 5, we talked about setting up for an M&A. Here it's all about having a successful M&A, getting that hockey stick value, turning the perceived value into something real that others can't ignore. And we showed how to align patents and filings and strategies to get the acquirer to think that you're valuable. So they come to you, not the other way around. And finally, we went right into the copycats. And we broke down what copycats, how your patent's going to stop copycats. Recognizing you need a diverse claim set, maybe inventing around your own invention. We talked about other episodes on copycats directly. We talked about how you can change your websites, your marketing, maybe even brand, how you can signal the customer not to use a copycat. We also talked about defense here, where you should recognize that if you're going to approach a copycat, watch out for declaratory judgments, bring in prestigious law firms, that's sort of tricks of the trade, leveraging continuations, creating new IP versus invent around, and using even FTO, free to operate countermeasures, so copycats, have less impact over you. So we talk about these 6 topics, and in part number 2, come back and we'll talk about the rest. This is John Cronin, Invent Anything. Thanks for coming. And if you like what you heard, please thumbs up for us and maybe go to our podcast on Inventors at Work.